Tyler James Robinson intentionally or knowingly caused the death of Charlie Kirk. Notice conviction of this offense may carry the death penalty.
The man accused of assassinating conservative activist Charlie Kirk is now facing the court of law and the court of public opinion. With prosecutors pushing for the death penalty and evidence piling up,
I do not take this decision lightly, based solely on the available evidence and circumstances and nature of the crime.
Tyler Robinson's case is shaping into one of the most high-profile trials Utah has ever seen. Let's explore what comes next.
State of Utah versus Tyler James Robinson. Could you state your name?
Tyler James Robinson.
Tyler Robinson, the 22-year-old accused of gunning down political activist Charlie Kirk, appeared in court today for the very first time. The hearing was held virtually, with Robinson joining from the Utah County Jail, and it gave us our first look at how prosecutors are going to frame this case. You just heard the charges read out by Utah County Attorney Jeff Gray: aggravated murder, firearm discharge, obstruction of justice, and witness tampering, among others.
The state is also charging defendant with count 4, obstruction of justice, a second-degree felony for disposing the clothing he wore during the shooting. Count 5, witness tampering, a third-degree felony for directing his roommate to delete his incriminating texts. Count 6, witness tampering, a third-degree felony for directing his roommate to stay silent if police questioned him. And count 7, commission of a violent offense in the presence of a child, a Class A misdemeanor, for committing homicide knowing that children were present and may have seen or heard the murder and did so based on Charlie Kirk's political expression.
But here's the key point. Gray didn't just stop at the charges. He announced his office will also file a notice of intent to seek the death penalty. That decision alone makes this one of the most consequential trials Utah has seen in years.
I have reviewed the pretrial protective order and will be issuing this pretrial protective order in favor of Erica Kirk. Is there any other business that we need to address today, counsel?
Just for the court's information, we did file just recently, within the last few minutes, a notice of intent to seek the death penalty that was filed by Utah County Attorney Jeff Gray. So that should be in the court's file.
Presiding over the hearing was Judge Tony Graff Jr., who kept the session focused and straightforward. Robinson himself barely spoke, only confirming his name. The judge ruled that he will remain held without bail while the case moves forward.
Mr. Robinson, I also wish to inform you of your right against self-incrimination. Anything that you say in court today could be used against you, and we want to protect your constitutional rights. Mr. Robinson, at this time, you will remain in custody without bail.
On the defense side, attorney Greg Skordas appeared briefly, explaining that he wasn't Robinson's official lawyer, but was working with the county to secure qualified counsel. Because this is a death penalty case, Utah requires attorneys with Special Rule 8 certification, a step that could take days to finalize. Also present in court were members of the prosecution's trial team: Chad Grunander, Ryan McBride, Lauren Hunt, David Sturgill, and Chris Ballard, who will be leading the state's case against Robinson. So what did this first appearance really tell us? It set the stakes. The state is calling this not just a homicide, but an aggravated, politically motivated assassination. By formally moving toward the death penalty, prosecutors are sending a clear message about how seriously they view this killing. The next step is already scheduled. Robinson will return to court on September 29th at 10 a.m. for a hearing where he'll decide whether to waive his preliminary hearing. That's when the prosecution will begin presenting the evidence they say proves he carried out this attack. After announcing the charges, Jeff Gray gave the public a first look at the evidence his office believes ties Tyler Robinson directly to the killing of Charlie Kirk. And make no mistake, the state is calling this a forensic case, one built on hard evidence, not just eyewitness accounts. According to Gray, the murder weapon is the centerpiece. Investigators say Robinson used his grandfather's Mauser 98-30-06 rifle with a mounted scope. After the shooting, the gun was allegedly stashed in nearby woods, along with a towel and leftover ammunition.
The rifle was recovered in a wooded area where the shooter had fled. So the FBI laboratory will be analyzing this weapon. Investigators have also collected footwear impression, a palm print, and forearm imprints for analysis.
Forensic testing was immediate. DNA consistent with Robinson's was recovered on the trigger, on a fired cartridge casing, on 2 of 3 unfired rounds, and on the towel. In the prosecution's view, that places the rifle and the shooting sequence squarely in Robinson's hands. The home search added weight. Executing a warrant, police say they found a shell casing with distinctive etched markings inside Robinson's residence. Those markings, prosecutors contend, match the etchings on casings recovered near Utah Valley University. Officers also seized multiple paper targets riddled with bullet holes. Prosecutors shorthand for practice and preparation, not a spontaneous act. Then came the surveillance footage. Authorities claim Robinson was captured on video before, during, and after the shooting, including while positioned on a rooftop overlooking the event. One clip allegedly shows him moving with what prosecutors called an unusual gait. His right leg appeared stiff, barely bending as he crossed campus. According to Gray, that walk was consistent with someone concealing a long rifle in their pants. If true, it would mean Robinson carried the weapon onto campus deliberately, positioning himself before the fatal shot.
The suspect walks with very little bending in his right leg, consistent with a rifle being hidden in his pants. This unusual gait continues until the suspect is seen crossing the railway off the open walkway and onto the roof, where he leaves the camera's view.
There's also the ammunition itself. Investigators say several rounds were engraved with cryptic or mocking phrases. "Hey fascist, catch!" "Bella ciao," and meme-style quips such as, "If you read this, you are gay LMAO," with online chatter also referencing "Uwu notices bulge." Prosecutors aren't asking jurors to decode internet humor. Their point is simpler. Engraving rounds happens before the shooting, which signals forethought and intent to leave a message behind. Pull the threads together, and the state's trial strategy comes into focus. First, touch DNA and item-to-item transfers to anchor physical possession. Second, toolmark etch-match evidence linking a casing at home to casings at UVU. Third, time-stamped surveillance to place Robinson moving toward, occupying, and leaving the shooting position. Finally, the custom-engraved ammo underscores planning and state of mind. No single exhibit has to do all the work. Prosecutors plan to stack them until the narrative feels unavoidable.
Investigators noted inscriptions that had been engraved on casings found with the rifle. Inscriptions on a fired casing read, "Notices bulges, capital OWO, what's this question mark?" Inscriptions on the 3 unfired casings read, "Hey fascist, exclamation point, catch, exclamation point."
The defense will get its chance to push back, arguing, for example, that the engravings were immature trolling, not ideology, or that unusual gait is subjective video interpretation. But those are attacks at the margins. The core remains. A scoped rifle, prosecutors say, was handled by Robinson, casings whose markings echo those found in his home, footage of a suspect traversing campus and taking a rooftop perch, and physical items bearing his DNA recovered right after the gunfire. If the forensic evidence forms the backbone of the state's case, the roommate testimony could be its heart. Prosecutors say Tyler Robinson not only planned the assassination of Charlie Kirk, but also tried to hide his tracks by leaning on the one person closest to him, his roommate. And that is where the witness tampering charges come into play. According to Utah County Attorney, investigators recovered a note Robinson left under his keyboard. The message was short but chilling. "I had the opportunity to take out Charlie Kirk, and I'm going to take it." That note was later photographed by police, but it was the roommate who first found it after receiving a text from Robinson telling him to look under the keyboard.
On September 10th, 2025, the roommate received a text message from Robinson which said, "Drop what you're doing, look under my keyboard." The roommate looked under the keyboard and found a note that stated, quote, "I had the opportunity to take out Charlie Kirk, and I'm going to take it."
The exchange that followed reads almost like a confession. When the roommate asked if Robinson was serious, Robinson allegedly replied, "I am. I'm sorry." In another message, he explained, "I had had enough of his hatred." Some hate can't be negotiated out. At one point, when asked how long he had been planning the shooting, Robinson admitted it had been a bit over a week. Prosecutors argue that this is not only evidence of premeditation, but also an outright admission of motive. But it didn't stop there. Robinson allegedly went further, asking his roommate to delete the entire conversation. In one message, he wrote, "Delete this exchange and don't talk to the media, please. Don't take any interviews or make any comments. If any police ask you questions, ask for a lawyer and stay silent." That request alone became the basis for 2 separate counts of witness tampering. Governor Spencer Cox previously told reporters that the roommate was cooperating with law enforcement, and the new filings confirmed just how important that cooperation has become. Not only do these messages provide direct insight into Robinson's mindset, but they also document his attempt to obstruct the investigation by silencing a key witness. Details about Robinson's relationship with the roommate has also surfaced. According to court documents, Robinson's mother described the roommate as being in a romantic relationship with him and as someone who was transitioning genders. While prosecutors did not dwell on that personal element, they emphasized that it explained why the two were so close, and why Robinson may have believed the roommate would protect him. Taken together, the note under the keyboard, the text exchanges, and the pressure to stay quiet form some of the most incriminating pieces of evidence in the case. Unlike forensic testing, these are Robinson's own words, captured, preserved, and now central to the prosecution's argument that this was a deliberate, politically motivated killing. While prosecutors have leaned heavily on forensics and digital evidence, another part of this story is deeply personal. Tyler Robinson's own parents played a critical role in ending the manhunt, and in doing so, they positioned themselves as both witnesses and reluctant participants in the case against their son. According to the Utah County Attorney, Robinson's mother was the first to suspect something was wrong. After law enforcement released surveillance stills of the suspected gunman at Utah Valley University, she reportedly looked at the images and feared they resembled her son. She raised the concern with Robinson's father, who agreed. That moment set in motion a family confrontation no parent would ever expect. The couple reached out to their son directly. During those phone calls, prosecutors say Robinson hinted at taking his own life rather than facing arrest. He implied that he couldn't go to jail and told his parents he just wanted to end it. In Gray's words, Robinson's parents were able to convince him to meet at their home. That meeting was tense. According to court filings, Robinson made statements that amounted to an admission, suggesting he had been the shooter. At that point, the family sought outside help. With the assistance of a family friend, they arranged for Robinson to surrender at the Washington County Sheriff's Office.
On the evening of September 11th, a family member of Tyler Robinson reached out to a family friend who contacted the Washington County Sheriff's Office with information that Robinson had confessed to them or implied that he had committed the incident.
He was taken into custody without incident, ending the statewide search that had gripped Utah for more than a day. For prosecutors, these details matter. Not only do they highlight Robinson's acknowledgement of involvement, but they also mean his parents could be called as potential witnesses during trial. Their testimony could corroborate his own words, adding another layer to the state's evidence. The case also reveals a deeper family divide. Gray told reporters that Robinson's parents are registered Republicans, while Robinson himself had recently leaned more to the political left, becoming outspoken on issues like LGBTQ rights. That difference reportedly strained conversations at the dinner table, especially as Kirk's upcoming event at Utah Valley University was mentioned by Robinson before the shooting.
Investigators interviewed a family member of Robinson who stated that Robinson had become more political in recent years. The family member referenced a recent incident in which Robinson came to dinner prior to September 10th, and in the conversation with another family member, Robinson mentioned Charlie Kirk was coming to UVU. They talked about why they didn't like him and the viewpoints that he had. The family member also stated Kirk was full of hate and spreading hate.
Legally, the role of Robinson's parents is complicated. They are witnesses who may have to testify to what they saw and heard, but they are also grieving parents dealing with the reality that their own son stands accused of assassinating a nationally known political figure. It was a turning point in the investigation. Without his parents' intervention, Robinson may have attempted suicide or remained on the run. Instead, he was brought into custody, alive, by the very people who raised him, making this case not only a legal drama, but a family tragedy. One of the quieter but significant developments during Tyler Robinson's first court appearance involved the victim's family. As prosecutors laid out their case, they also asked the judge to issue a protective order for Erica Kirk, the widow of Charlie Kirk, and the court agreed. The order, granted by Judge Tony Graff Jr., prohibits Robinson from contacting Erica Kirk in any way.
I do have a few points I'd like to bring up with Your Honor. We have filed a pretrial protective order on behalf of Erica Kirk. We would ask the court to review that. It should be in your queue, Your Honor, and sign that.
Thank you. I have reviewed the pretrial protective order and will be issuing this pretrial protective order in favor of Erica Kirk.
That may sound symbolic, especially since Robinson is already held without bail inside the Utah County Jail. But legal experts say protective orders in violent crime cases are standard, and for good reason. Criminal defense attorney Bradford Cohen, who has worked on high-profile cases across the country, explained that these orders serve as an additional shield for victims' families. Even from jail, defendants sometimes attempt to reach out indirectly, whether through relatives, friends, or even third-party supporters.
In any case, they don't want them speaking to anyone else and saying, hey, you should really have a discussion with Erica, or see if she will back off the death penalty, or anything like that. And that's why they enter these orders. And it's typical in these type of cases. It's not just typical in these type of cases, it's typical in any kind of violent crime whatsoever.
In a death penalty case, where emotions are running high and pressure on witnesses can shape outcomes, prosecutors want to eliminate any chance of harassment or intimidation. That concern is especially relevant here. Robinson is already facing 2 counts of witness tampering, accused of trying to pressure his roommate into deleting incriminating messages and staying silent if questioned. Prosecutors don't want a repeat of that dynamic with the victim's widow. By securing a protective order, they're ensuring Erica Kirk doesn't become a target of unwanted contact, persuasion, or manipulation as the case unfolds. There's also a psychological component. For families of homicide victims, court proceedings can be grueling. Protective orders give them some peace of mind, removing the fear that the defendant, or anyone acting on his behalf, might attempt to influence them. As Cohen put it, it's typical in any violent crime, but especially in high-profile cases like this one. For Erica Kirk, the order represents a small measure of protection in the aftermath of an enormous loss. Her husband's killing wasn't just public, it was political, and it drew international attention. Prosecutors know that puts her at risk of being pulled into the public debate, or worse, being pressured in private conversations. The protective order doesn't change the charges, and it doesn't affect Robinson's custody status. But it adds another layer to how the court is managing this case. With the death penalty on the table, every safeguard, whether for witnesses, for evidence, or for family members, is being treated as essential. As prosecutors build a case they say is grounded in science, surveillance, and Robinson's own words, one question looms: how can the defense possibly respond? Legal experts point out that when evidence appears this overwhelming, the job of defense attorneys shifts dramatically. Instead of proving their client's innocence outright, they often focus on limiting damage, challenging the harshest charges, and, in capital cases, avoiding the death penalty. Criminal defense attorney Bradford Cohen, who has handled high-profile cases across the country, explained it bluntly.
In quite a few cases where the evidence is overwhelming, but there's still this need to support this individual because people support, quote unquote, the cause that this individual allegedly stood for. So you see that quite often in these cases, and I wouldn't be surprised to see it. I think it's going to be very difficult to find a defense attorney that is going to be willing to put themselves on the line for this.
This isn't about whether he pulled the trigger. It's about whether the state can meet the elements of aggravated murder and justify execution. In other words, the battle ahead for Robinson's defense team may be less about who did it, and more about how the law defines it. One possible approach is to attack the aggravating factors that make this a death penalty case. Prosecutors allege Robinson targeted Charlie Kirk because of his political expression and fired into a crowd where children were present. But defense lawyers could argue that a single shot aimed at one individual doesn't meet the legal threshold of creating a grave risk to others. They could also push back on the claim of political targeting, questioning whether his motive truly fits Utah's statutory requirements. Another tactic could be to challenge the admissibility of certain evidence. For example, Robinson's bizarre bullet engravings. Phrases might be framed as irrelevant or prejudicial, rather than probative of intent. Similarly, text messages to his roommate could be attacked as hearsay, taken out of context, or obtained improperly. In capital cases, defense teams often try to keep as much evidence as possible away from the jury. But even if some of those challenges succeed, Robinson still faces forensic links that are hard to dismiss. DNA on the rifle, casings and towel, shell markings tied to his home, surveillance footage showing him on campus. As Cohen noted, you'd have to live on another planet to believe this guy walks free. For the defense, that means their most realistic goal may be to secure a plea deal that removes the death penalty from the table, leaving Robinson with life in prison without parole.
A mandatory term of imprisonment for life without parole, or an indeterminate term of not less than 25 years, and that may be for life.
It's a grim reality. In cases like this, defense attorneys often fight less for an acquittal and more for survival. For Robinson, the legal road ahead isn't about whether he faces punishment. It's about whether that punishment ends with a prison cell or a death chamber. The killing of Charlie Kirk wasn't just treated as a criminal act. It quickly exploded into a political flashpoint. Within hours of the shooting, the news was framed not only as the death of a conservative activist, but as an attack on the freedom of political expression itself. And in today's divided climate, reactions fell squarely along partisan lines. On the Republican side, tributes came quickly. President Donald Trump issued a statement promising that Kirk's message would live on, describing him as a fighter for America's youth and values. Vice President J.D. Vance a close friend of Kirk's, guest-hosted Kirk's own podcast in the days after the assassination, pledging that the movement he co-founded with Turning Point USA would not be silenced. Across conservative media, the shooting was framed as proof of escalating hostility toward right-wing voices. In Utah, Governor Spencer Cox called the killing an American tragedy and emphasized that the state would pursue justice to the fullest extent of the law. Cox also revealed that Robinson's roommate had been cooperating with authorities, highlighting the role witnesses played in bringing the suspect into custody. For state officials, the message was clear. This was not only an attack on one man, but an assault on the democratic principle of open debate. Democrats, meanwhile, condemned the violence, but were quick to warn against politicizing the tragedy.
I'm just going to state the obvious here. This is detestable, what's happened. Political violence has become all too common in American society, and this is not who we are.
Some argued that the cycle of inflammatory rhetoric on both sides had contributed to a climate where political violence was becoming more common. That response drew immediate pushback from conservatives, who accused their opponents of deflecting blame rather than acknowledging the targeting of a conservative leader. In Congress, the shooting intensified scrutiny of the FBI. Director Kash Patel testified that investigators were running down every lead, including Discord group chats, where Robinson allegedly admitted involvement. Patel defended his agency's handling of the case, but he was grilled by lawmakers, especially Republicans, over whether the Bureau was doing enough to prevent political violence against conservative figures. Outside Washington, the public reaction was intense. Vigils were held not only across Utah, but as far away as Berlin, where Kirk had a following among conservative youth groups. Signs reading, "Free speech should not be fatal," captured the sentiment of many supporters. At the same time, online spaces erupted with conspiracy theories, some suggesting Robinson was part of a larger plot, others accusing the media of exploiting Kirk's death for political gain. As the case against Tyler Robinson heads toward trial, one of the most important battles won't be about who fired the fatal shot. Prosecutors believe their evidence answers that, but about how the crime is legally defined. The charges filed include aggravated murder, the most serious homicide offense under Utah law. And what makes the difference between aggravated murder and ordinary murder is the aggravating factors. Prosecutors say there are two main aggravators here. First, Robinson targeted Charlie Kirk specifically because of his political expression. Second, the killing was committed in front of children, who were present in the audience at Utah Valley University and may have directly witnessed the shooting.
Charging Tyler James Robinson, age 22, with the following crimes. Count 1, aggravated murder, a capital offense, for intentionally or knowingly causing the death of Charlie Kirk under circumstances that created a great risk of death to others. Count 2, felony discharge of a firearm causing serious bodily injury, a first-degree felony. The state is further alleging aggravating factors on counts 1 and 2 because the defendant is believed to have targeted Charlie Kirk based on Charlie Kirk's political expression and did so knowing that children were present and would witness the homicide.
By adding those aggravators, Jeff Gray was able to justify not just the aggravated murder charge, but also his office's decision to pursue the death penalty. But here's where legal experts say the defense may push back. On the issue of political targeting, attorneys could argue that while Robinson clearly disagreed with Kirk's views, the state must prove beyond a reasonable doubt that those views were the driving reason for the murder. Motive cases are tricky. Unless the prosecution can tie Robinson's statements directly to Kirk's political positions, the defense could frame it as a personal act of violence rather than a politically motivated assassination. The second aggravator, children in the crowd, also raises questions. Defense lawyers might argue that a single shot fired at one individual, even in a public space, does not automatically meet the threshold of creating a grave risk to others. Was Robinson targeting the children, or even aware of them in that moment? The state insists that knowingly carrying out a homicide in a setting where children were present is enough. But defense counsel could challenge whether that truly elevates the crime under Utah law. Another point of contention could be witness tampering. Robinson's texts to his roommate telling him to delete conversations and stay silent are undeniably incriminating. Yet the defense may argue those were emotional, panicked messages rather than calculated attempts to obstruct justice. In high-profile cases, trimming away enhancements like these can be one way for defense teams to reduce sentencing exposure. Legal analyst Bradford Cohen put it bluntly, "You don't beat the murder charge, you fight the aggravators."
The squeeze on that, maybe the defense attorney to try and chalk one up on the board, maybe it's worth trying to argue that, hey, this isn't a witness tampering case, or this isn't aggravated murder, it's just regular murder. I don't know. I think that that's the only argument they're going to have at a preliminary hearing. I think ultimately they're going to beg for to take the death penalty off the table.
For Robinson's defense, that may be the only viable strategy. Chip away at the state's enhancements, try to remove the death penalty from the table, and leave the case as a standard murder prosecution. Charlie Kirk's assassination was never going to stay a local Utah story. Within hours, it became a national debate about politics, free speech, and the dangerous rise of political violence in America. What happened on a college campus in Orem suddenly carried implications for the country as a whole. For conservatives, the killing was framed as an attack on free expression itself. Kirk was not a government official, but a prominent activist who made his career debating hot-button issues: gun rights, abortion, transgender policies, and immigration. To many of his supporters, the fact that he was targeted while speaking on stage symbolized an effort to silence conservative voices. Turning Point USA vowed to continue its mission, and President Donald Trump declared that Kirk's legacy would not be erased by a single act of violence. For Democrats, the message was different. They condemned the murder, but pointed to a deeper problem: the overall climate of hostility and inflammatory rhetoric that now surrounds American politics. Some argued that both sides have contributed to the polarization that makes violence more likely.
Political violence in any form against any American is unacceptable, should be denounced by everyone, and moving forward, we have to figure out a better way to come together, not as Democrats or Republicans, but as Americans.
That framing angered Republicans, who saw it as an attempt to blur the fact that Kirk, a conservative leader, was deliberately targeted. The case also pulled the FBI into the spotlight. Kash Patel faced sharp questioning in Congress about how the Bureau was handling the investigation, particularly after reports that Robinson used Discord chats to discuss the shooting.
On top of that, unfortunately, it has been leaked that there was a Discord chat, and for those unfamiliar with it, it's a gaming chat room online that the suspect participated in. So what we've already done is serve legal process, not just on Discord, so that the information we gathered is sustained and held in a evidentiary posture that we could use in prosecution should it be decided to do so. And we're also going to be investigating anyone and everyone involved in that Discord chat.
Okay, very good. I see the public reports that the Discord thread had as many as 20 additional users. It sounds like you're trying to run down all of that to see if that's accurate, who else may have been on that thread, what they may have known. Is that fair to say?
It's a lot more than that, and we're running them all down.
It's a lot more than 20?
Yes, sir.
Patel defended his agents, describing thousands of leads being chased down and enhanced surveillance footage being released to help identify the suspect. But Republicans accused him of being slow to act, while Democrats pressed him on whether the Bureau was inflaming partisanship by highlighting Robinson's political leanings. Meanwhile, Outside Washington, the assassination sparked vigils and protests across the U.S. and even overseas. Supporters in Berlin and London held candlelight gatherings, carrying signs that read, "Free speech should not be fatal." At the same time, online platforms exploded with conspiracy theories. Some claimed Robinson was part of a broader left-wing plot. Others suggested law enforcement was covering up deeper connections. None of those claims have been substantiated, but they reveal just how quickly tragedy becomes fuel for America's cultural battles. The larger question is what this case represents. Is it a one-off act by a disillusioned young man, or is it a sign of where American politics is heading? Legal experts warn that if the country normalizes violence as a response to disagreement, the consequences could stretch far beyond this single case. As one commentator put it, if Charlie Kirk can be assassinated for his opinions, who's next? With charges filed and the first court appearance behind him, Tyler Robinson's case now moves into its next phase. The immediate step is a preliminary hearing, currently set for September 29th. At that hearing, prosecutors will present enough evidence to show there is probable cause for the case to proceed to trial. The bar is low. Judges rarely dismiss cases at this stage, but the defense will get its first real preview of what evidence the state intends to bring. From there, the process splits into two possible paths. Robinson can choose to contest the charges, forcing the case toward a full jury trial, or he can seek a plea agreement. In a death penalty case, plea negotiations usually revolve around one thing: taking execution off the table in exchange for life without parole. Legal analysts say it's unlikely prosecutors would make that concession without Robinson admitting guilt to aggravated murder and the enhancements tied to it. If the case proceeds to trial, it will be lengthy and high-profile. Prosecutors, Gray, and trial lawyer Chad Grenander have already signaled their intention to introduce a wide array of forensic evidence, digital communications, surveillance video, and testimony from Robinson's own parents and roommate. On the defense side, once qualified counsel is officially appointed, their strategy will likely center on chipping away at aggravating factors, arguing that political targeting or the presence of children doesn't meet the legal threshold for capital punishment. Another factor is the role of the victim's family. Under Utah law, victims and their families have input during sentencing phases, especially in capital cases. That means Erica Kirk, Charlie Kirk's widow, will likely have a voice in whether prosecutors continue to seek the death penalty or consider a negotiated resolution. Observers note that in many death penalty cases, the wishes of the victim's family can heavily influence the outcome. Meanwhile, the federal government is still watching closely. FBI director has said his agency is investigating possible federal charges, which could include offenses tied to political assassination or firearms violations. Whether the federal government steps in will depend in part on how Utah pursues its case and on conversations with Kirk's family. For now, Robinson remains held without bail, awaiting his next hearing. The trial may be months, even years, away, but the trajectory is already clear. The state wants to prove this was more than murder. It was an assassination that struck at the heart of free speech. For Robinson and his defense team, the goal is just as clear. Avoid the death chamber, no matter the cost. The evidence may look overwhelming, but will a jury see it the same way? Tyler Robinson's fate now hangs in the balance of a trial that could rewrite the conversation about political violence in America.